As Edo people await the outcome of the Edo State Governorship Election petition tribunal, tension appears to be brewing from both camps, particularly from supporters of the petitioners and even the respondents. Not too long ago, parties in the petition adopted their final written addresses, praying the tribunal to either upturn or uphold the election. We revisited the issue canvassed by parties in this special report done by our senior reporter, First Orator, who chronicles the issue raised by parties. The report.
It is no longer news that election into the office of the governor of Edo State was conducted on 21 September 2024 by the Independent National Electoral Commission (INEC), where INEC declared Senator Monday Okpebholo and the APC winner of the election after APC polled 291,667 votes to defeat other candidates and the political parties. However, what is news here is that Edo people are expectant of what would likely become the outcome of the Justice Wilfred Kpochi-led three-man panel of Edo State Governorship Election Petitions Tribunal, parties having adopted their final written addresses earlier in this month. And so in this special report, we crave your indulgence for the next 20 minutes or more as we delve into the main issues canvassed by parties during the adoption of final written addresses. So sit back and enjoy these special reports. Politicians and interested parties in Edo State and beyond are all waiting for the Justice Wilfred Kpochi-led three-man panel to announce a date for the judgment of Edo State Governorship Election Petitions Tribunal. In the final written addresses by parties, revealed that the petitioners who were dissatisfied with the declaration and return of the second respondent, Senator Monday Okpebholo, filed a petition on 11th October 2024, wherein they challenged the result of election in several hundreds of polling units across the 18 local government area of Edo State. The main grounds of the petition is that in the results declared by the first respondent, that is, the Independent National Electoral Commission allegedly reckoned with invalid votes, collated incorrect scores, and also collated results which are not in tandem by polling unit results. The petition is predicated on two grounds: that the election was invalid by reason of non-compliance with the provisions of the Electoral Act 2022, and that the second respondent, Senator Monday Okpebholo, was not duly elected by majority of lawful vote cast at the election. Allegations of non-compliance in the petition in support of ground one are confined to the conduct of the election in 453 polling units out of the total of 4,519 polling units in Edo State. The allegations of non-compliance are rather two subheads. The first is predicated on the contravention of the provisions of Section 73(2) of the Electoral Act 2022 in 395 polling units, resulting from the failure to prior recording of the serial numbers and other particulars of result sheets, ballot papers, beavers machines, and other sensitive materials in Form EC 25B. The second non-compliance addresses the issue in Section 51(2) of the Electoral Act 2022, in that the total vote cast as recorded in Form EC 8A in 133 polling units exceeded the total number of accredited voters based on the beavers record of accreditation. The trial of the election petition commenced on the 15th day of January 2025, with the petitioners opening their case. They tendered some certified true copies of polling unit result sheets from Form EC 8A, voters registers, beavers screenshots, beavers results, from EC 8A downloaded from the IREF portal, and sundry other electoral documents from the bar as exhibits PA1 to PJQ. The petitioners also called 19 witnesses, PW1 to PW19, through whom they tendered some duplicates of agent copies of polling unit result sheets from EC 8A, agent tags, and sundry other documents as exhibits. They also tendered 153 beavers machine devices from the bar as exhibit PPDD1 to PPDD153, which were produced before the tribunal by an official of INEC based on the subpoenaed Duse Tecom exhibit PPCC issued by the tribunal. The petitioners closed their case on the 3rd day of February 2025, whereupon the respondents were called upon to open their defense. In defense of the claim, the first respondent tendered certified true copies of some of the election documents, including the state collation result sheet from EC 8D, the declaration of result sheet from EC 8E, and the regulation of guidelines for the conduct of election 2022 from the bar,
as Exhibit R1, R2, and R3 respectively, and closed its case on the 6th day of February 2025 after indicating that it shall be relying on the evidence elicited under cross-examination of the petitioners and respondent witnesses. The second respondent, Senator Monday Okpebholo, on his part, opened his defense on the 10th day of February 2025 by calling a single witness, RW1, a poly unit agent for Unit 4 of Ward 7 of Ovia Southwest local government area, who adopted his witness statement on oath and tendered his agent tag as Exhibit R4 before the tribunal. The second respondent closed its case on the 10th day of February 2025 after indicating that he shall also rely on the evidence elicited under cross-examination of the petitioners and respondent witnesses. The third respondent opened its case on the 12th day of February 2025 and called 4 witnesses, RW2, RW3, RW4, and RW5, who were local government area collation agents of the second and third respondents during the election. These witnesses adopted their various witness statements on oath and tendered their permanent voter cards and agent tags. The complaints of the petitioners in 1 and 2 of the petition came under 3 subheads. The first is that in 312 poly units, the first respondent, INEC, failed to collate the lawful scores of the petitioners, and the second and third respondents, as contained in Form EC8A, which were duly scanned by its presiding officer and uploaded to INEC database for storage, counterpart copies of which were handed over to the agents of the political parties. The second grounds is that in 76 of the above referred 312 poly units, the first respondent failed to collate the poly unit results in Form EC8B at the ward level. This, they claimed, happened in Ward 2 of Ipobaha local government area. Another case of the petitioner is the invalidation and cancellation of the results of the election in 453 poly units. They said the tribunal may find proof and the cancellation of the lawful scores of the parties in the 312 poly units where allegations of incorrect collation of exclusion of poly units results are made, which substantially affected the result made at the election, with the ultimate result that the petitioners will become the winners of the election with 240,234 lawful votes, and the second and third respondents will become the runner-up in the election with 201,832 votes. At the close of trial and assessment of evidence led, the figures, according to the petitioners, are now reversed to 218,876 for the second and third respondents and 243,113 for the petitioners. However, in response to this petition, the respondents said the issue of prior recording, overvoting, incorrect non-collation, and wrongful cancellation of results from poly units to poly units, and to adduce direct eyewitness and documentary evidence of alleged irregularities and non-compliance is a matter of law, and cited Uche versus Elechi 2012 case. They said the Supreme Court in Rodas Vivo JSC clarified the position of the law that held that where a petitioner complained of non-compliance with the provisions of the Electoral Act 2010 as amended, he has a duty to prove it poly unit by poly unit, word by word. He must show figures that advanced party was credited with the result of the non-compliance in Form EC8A, election materials not stamped, signed by presiding officer. He must establish that non-compliance was substantial, that it affected the election results. It is only then that the respondents are to lead evidence in rebuttal, and also cited the case of Buhari versus Obasanjo 2025, Awolowo versus Shegari 1979, and supplied relevant documents. They submitted that in the instance case, the petitioners have woefully failed to meet the requirements of the law or discharge the evidential burden of proving the allegation of failure to prior recording of serial numbers and proved overvoting in any of the poly units complained about in the petition. The respondents said that the duty of prior recording of serial numbers and quantities of sensitive electoral materials is the responsibility of the presiding officers of the first respondent INEC assigned to each of the poly units, and that responsibility is required to be discharged by the presiding officers before the commencement of the polls at the various poly units of the election according to Section 73(1)(3) of the Electoral Act 2022. The respondents, however, submitted a prior recording being an activity that is required to take place at the polling units of the election prior to the commencement of the polls. The evidence required to prove the alleged failure to discharge that responsibility must necessarily come from persons who took part in the electoral process at the polling units and who witnessed the alleged dereliction of duty on the part of the presiding officer and the non-prior recording of serial number and quantities of sensitive electoral materials at the polling units, and cited the case of OK versus Mimiko, where the Supreme Court stated the law and held as follows: that Section 45(2) of the Electoral Act expects evidence directly from the relevant field officers at the required polling units. Also, in the case of Mariga versus Another and Akali and others, where the appeal court pertinently held that the appellants did not call any polling unit agent to testify as a witness. Rather, the first appellant testified as a candidate and called word collation agents. The appeal court said none of them showed that he was at any of the polling units for any reasonable length of time, nor testified that he was present during the accreditation of voters, voting, collation of results, entering of results, informiciate and announcement of results. And the court held that the evidence of all the witnesses in that case, PW1, PW2, PW3, and PW4 in the reference case amounted to hearsay. APC and Edo People said in the instance case, the petitioners who alleged that the first respondent INEC officials failed to comply with the requirement of the law of prior recording of serial numbers and quantities of sensitive electoral materials in about 395 polling units across the 18 local government areas of Edo State, called only 19 witnesses to testify in proof of the allegation. They said witnesses consisted of 10 persons, PW1 to PW10, who claimed to have acted as local government area collation agents, 3 witnesses, PW11 to PW13, who claimed to have acted as ward collation agents, 5 persons, PW15 to PW19, who claimed to have acted as polling unit agents, and 1 person, PW12, who claimed to have acted as the Director of Research and Strategy for the petitioners. The respondents submitted that the bulk of the petitioners' witnesses, PW1 to PW19, are completely alien to the events that took place at the polling units on the day of the election, because they are not polling unit agents and cannot therefore give direct eyewitness evidence as to what transpired at the polling units. On the issue of alleged non-prior recording, they said the petitioners' failure to call their polling unit agent is fatal to their case, citing the case of Baba and Another versus INEC and Another, where the Supreme Court held in similar circumstances as in this case as follows: that the appellants have an onerous duty to most especially plead each and every specific polling unit so challenged, and thereby lead credible documentary and oral evidence substantiating the allegation regarding the affected polling units. The respondent said in the instance of the PW1 to PW14 of the PDP and Aswan Godalo under cross-examination that they personally examined the electoral forms after the election, and their testimony is based on what they discovered from the examination of the document exposes incontrovertibly that their testimony is inadmissible hearsay. They said the law is well settled that the petitioner must adduce direct eyewitness evidence of what transpired in an election petition and not the hearsay testimony of those who picked the information from studying the document, and also cited the case of Andrew Izeyamo and Another versus INEC and others, where the Supreme Court said the appellants have admitted in their brief that the evidence of their witnesses did not arise from what they witnessed on election day when the entries in the electoral forms were being made. It noted that those witnesses did not take part or participated in the conduct of the election, nor were they present at any of the stages of which the electoral forms, documents, or materials which form the basis of their evidence were recorded, prepared, or entries thereon made. The Supreme Court said in an election matter such as the instant case, the evidence required is not the one which was picked up from perusing documents made by others. Otherwise, anyone with basic comprehension arithmetic skills would be able to testify anywhere in Nigeria. The requirement of the law is that a petitioner must call eyewitnesses who were present when the entries in the forms were being made and can testify to those entries in the document and how the documents were arrived at. It is to be noted that the appellant's witnesses were not the makers of the document in respect of which they testified and were not there when the documents were made. They were thus not competent or capable of giving testimonies and explain the circumstances surrounding how the entries in the election documents were made, and cited the case of OK versus Mimiko. Again, the respondent said that even the 5 witnesses, PW15 to PW19, who claimed to have acted as polling unit agents for the petitioners during the election, did not testify in respect of the allegation of non-prior recording of serial numbers and quantities of sensitive electoral materials, and were also not cross-examined along those lines. The totality of their testimony related to alleged overvoting and had nothing to do with the issue of non-prior recording. What that means, according to the respondents, is that the PW15 to PW19 did not adduce any evidence in support of the allegations of failure of the presiding officer to prior recording serial numbers and quantities of sensitive election materials before the tribunal, and are therefore of no avail to the petitioners in that regard. In other words, the respondents said the petitioners did not call any polling unit agents to prove the allegation of no prior recording, and that failure is fatal to the petitioner's case. They also referred the tribunal to Baba and another versus INEC and another in a Supreme Court case. They said the petitioners also tendered documents from the bar which were admitted by the tribunal as exhibit PCA 1 to PCA 320, certified 3 copies of polling unit results from EC8A, exhibit PEAI to exhibit PEA 75, that is, the certified 3 copies of IRF polling unit result sheets from EC8A, exhibit PCB 1 to PCB 308, certified 3 copies of polling unit booklets containing from EC25B, EC40A, and EC40C, and exhibit PEB1 to PEB706, certified 3 copies of polling unit booklet containing from EC25B, EC40A, and EC40C. They said despite this volume of documents submitted by the petitioners, the respondents said the documents were dumped on the tribunal without demonstration as required by law and are therefore inadmissible and of no avail. They said their makers were not called to testify before the tribunal or to be cross-examined, and no witness were called from the polling unit to demonstrate the said document before the tribunal. They said in the final written address that in past Supreme Court judgment, Andrew and another versus INEC and others, the Supreme Court stated that tendering of documents without adducing evidence which linked the document and the particular complaint of the party is fatal. This is because it is not the duty of the court to examine the document outside the tribunal. In Beggar versus Ahmed, the Supreme Court emphasized the fact that where the maker of a document is not called to testify, the document will not be accorded probative value, notwithstanding its status as a certified public document. Also, in the case of Omishore versus Aregbe-Shola, the court held as follows. In other words, the documentary evidence, no matter its relevance, cannot on its own speak for itself without the aid of an explanation relating its existence. The validity and relevance of documents to admit facts or evidence is when it is done in the open court and not a matter of caseless address. It is also not the duty of a court to speculate or work out either mathematically or scientifically a method of arriving at an answer on an issue which could only be elicited by credible and tested evidence at the trial. The respondents said the petitioners neglected and failed to call any of their polling unit agents from the 395 polling units complained about to speak to and demonstrate the said exhibits. The respondents claimed that the petitioners who alleged that the election was marred by incidences of overvoting woefully failed to produce and tender admissible copies of the BVAS machines and the voters register used by the first respondent INEC for the accreditation of voters and conduct of election to enable the tribunal consider and determine the issue of alleged overvoting. They said the copies of the BVAS machines and voters register tendered by the petitioners as exhibit PPDD1 to PPDD153 and exhibit PDB1 to PDB55, PEC1 to PEC66 from the bar are inadmissible in evidence and cannot be relied upon by the tribunal because they were dumped on the tribunal. The makers of the records in the BVAS machines and voters register were not called to tender them as no witness who made entries on the BVAS machine or in the voters register was called by the petitioners to demonstrate them in evidence or to link them to the part of the case of the petitioners as required. They said in Begog versus Ahmed 2023, the Supreme Court clarified the position of the law and held that the proper person to tender a document is its maker, who alone can be cross-examined on it, and where a person who did not make it tenders it, the court ought not to attach probative value to it since the witness cannot be cross-examined on it. In the final analysis, the respondent urged the tribunal to dismiss the petition for lacking in merit and to find in favor of the election of the second respondent as declared by the first respondent for the following reason: that the petitioners failed to plead and prove all the results of the election, that the petitioners failed to call direct eyewitness evidence of presiding officers, polling unit agents, or registered voters who were present at the polling units, that the 19 eyewitnesses called by the petitioners were mostly ward and local government area collation agents who gave hearsay evidence of what allegedly transpired at the polling units and the results which they did not make and were not present when they were made, that all the documents tendered by the petitioners from the bar were dumped on the tribunal as their makers were not called to testify to demonstrate them and to link them to the various aspects of the complaint in the petition before the tribunal, that the petitioners' witnesses who alleged no prior recording of serial numbers and quantities of ballot papers and other sensitive electoral materials were discredited under cross-examination before the tribunal, that the petitioners failed to prove the presumption of irregularity in favor of the declared results of the election and failed to prove their entitlement to any of the relief sought in the petition.
Those were the issues canvassed during the adoption of the final written address by the People's Democratic Party, the petitioners, and of course the respondents. Everything we have told you in this special report are all documented and are before the Justice Wilfred-led panel of the Edo State Governorship Election Petitions Tribunal. Although the tribunal has not announced a date for a judgment to be delivered, one thing is sure, that the Edo State Governorship Election Petitions Tribunal judgment will not exceed 180 days according to the Constitution. From Benin, Best Orator reporting for BTV News.